afternoon, Judge Mathopo.
Good afternoon, ACJ.
Thank you for availing yourself for this interview. Welcome. As you know, this interview takes place because there is an order of court that said we must do this interview afresh. And thank you for availing yourself once again. I see that you hold the degree of B.Proc and you were admitted as an attorney in 1989, is that correct?
That's correct.
And you practiced as an attorney from 1989 until about 2006, is that correct?
That's correct.
Yes. Do you want to just refresh our memories about the nature of your practice when you were practicing?
I don't know where to start, but it's a long road.
The main features of what types of cases you did in your practice.
ACJ, I practice in Johannesburg, and my practice was 2 blocks away from the High Court. I was a correspondent of choice by virtue of my proximity to the High Court, and with the result that I was fortunate that I was instructed to do almost and virtually everything that went to the High Court, and it equipped me to be a lawyer that I am today, and it kept me busy, and yeah.
So you were in practice for about 15 or 16 years or thereabout before you got appointed as a judge?
Yeah, 16 years.
16 years, yes. And you got appointed as a judge in 2006?
Yeah, 2006, having acted for just about under a year.
Yes. So you would have started acting maybe in
2004 and 5.
Yes, okay, all right. And then you were in the High Court up to June 2015?
I was in the High Court, in 2013, and I was invited to act at the SCA for the whole year in 2014, and I was appointed the following year in April in 2015, and I'm still there.
Yes. And during the time when you were judge in the High Court, you wrote quite a number of, or quite a few reportable judgments, is that correct?
That's correct.
Yes. Do you recall more or less about how many there were?
Oh, no, there were many.
Oh.
There were many, but...
Yes. Okay. And then if you look at the reported judgments that you penned while you were at the High Court, did they cover a lot of different branches of law, including constitutional law?
Yeah, ACJ, I wrote virtually on everything, the law of contract, the law
yes.
And as well as the constitutional law. And very early in my career on the bench, I wrote a judgment on censorship. It's the film publication matter, where I declare certain sections of that act unconstitutional, and it went to the Constitutional Court, and my judgment was confirmed through the pen of the late Justice Kwea. And thereafter, I had occasion to write a judgment which dealt with the arrests of a civil debtor, and that judgment gave birth to another judgment at the Cape Town High Court, and then all judgments went to the CC, and Chief Justice Mogoeng wrote a judgment which effectively did away with that section in the Act. So that section is no longer there. So then I would say I'm proud because I had foresight when I wrote that judgment. And when I was confirmed by the CC, it gave me pleasure.
I seem to remember that there were quite a few of your judgments that you wrote while you were in the High Court that were upheld in the Constitutional Court. Am I right?
Thank you. Thank you.
Yes. And then you went to the Supreme Court of Appeal, and you have been there since 2015.
Well, you would say 2014 because once I got the acting appointment, I never left that court.
Yes, okay, okay. So that makes it, what, 6 years, 7 years?
7 years.
7 years. And in the meantime, you have acted in the Constitutional Court.
Yeah, for just about 18 months.
You have acted for 18 months.
18 months. Yeah.
Yes.
Yeah. When
yes.
COVID struck, I was at the High Court and I became a beneficiary of COVID and had to stay
You
on.
mean in the Constitutional Court? You said
Yeah.
High Court.
Constitutional Court.
Yes.
Mm.
Okay. So you have stayed there for quite some time.
Yes.
How did you find the Supreme Court of Appeal when you arrived there, in terms of now doing a lot of, or doing exclusively appellate work as opposed to when you were in the High Court doing motion court, trial matters, as well as full bench appeals?
One would sit at the High Court in full bench appeals, full court appeals. So getting an invitation to go to the Supreme Court of Appeal was purely an extension of what we were doing at the High Court, except that the numbers were increased. Instead of 32, we are now 5. So the panel had to be 5. But basically, the experience at the High Court equipped me to have what I would call a smooth ride at the Supreme Court of Appeal.
Well, I take it that you have enjoyed yourself in the Constitutional Court, otherwise you would not have made yourself available.
I did.
Share with the commissioners some of your experiences in dealing with different matters in the Constitutional Court that you have dealt with, maybe 2 or 3 matters that you would think are important, where you have written judgments.
Well, firstly, during my first year of acting, or first month, I had occasion to write a judgment, I think this was my first, on the doctrine of common purpose and its applicability to the crime of rape. You would remember, and for the benefit of the other members of the commissions who may not be lawyers, that principle applied arbitrarily in the sense that where there would be what you'd call gang rape, the perpetrator who penetrated would be the one who's charged with rape. So when the matter came to the Concord, when I was allocated scribe duties, I looked at it and I said, this cannot be right. Rape is a power offense. It's not only the person who penetrates who's guilty. Actually, there are people around you, around the rapist, who are violating the poor woman or the vulnerable woman there. And I said, they cannot be allowed to go scot-free. This judgment was written against the backdrop of various judgments in the High Court, judgments in the SCA. I had to distinguish them. And also, various authors of criminal law were of the view that rape would be relating to one or that person who penetrated. But when you look at it, I mean, I live in South Africa, and that cannot be. I mean, it's offensive. You could just pause for a moment and imagine that woman who's been raped, only to be told that only the person who penetrated her is the one who's going to be found guilty of rape. That can't be right. So I said, no. Fortunately, my colleagues agreed with me, and then I penned a judgment, and which now says it applies to them. And the law books would have to change and to reflect what I have said in the judgment.
Yes. And during your time in the Constitutional Court, have you had a chance to deal with matters where you invoke reading in or reading down?
Yes, I did, but not necessarily that I wrote those judgments.
Yes.
No.
But you were part of the
I
panel.
was part of the panel.
Yes. And I'm sure, having acted for so long, there are pieces of legislation where you've written a judgment and found the piece of legislation to be unconstitutional, and you invoked constitutional remedies.
Well, yes.
Yes. Yes. Okay. Commissioners. Commissioner Mwemang. Have I got it right? Not exactly.
Tata, Acting Chief Justice.
Okay.
Good afternoon, Justice Mathopo.
Good afternoon, Commissioner Mwimang.
I'm attracted to one judgment that you penned on the Minister of Justice versus South African Restructuring and Insolvency Practitioners Association. It dealt with the policy by the department, and I want to believe that it was probably prompted by the demand to transform the briefing pattern, and hence there was a need for the department to intervene. But I see that it was the policy was set aside based on rigidity and also taking away the power of the master to make an appointment, because among the issues raised in the policy was the issue of the quota. Given the fact that the outcry of briefing pattern remains, do you think that the matter could have been approached differently so that it does not contravene some of the values that you raised around rigidity, accountability? Thank you, Chief Justice.
Mr. Commissioner Mwimang, that judgment was written against the background that insolvency practitioners, okay, let me put it this way, just take a step backwards. The insolvency work used to be the exclusive domain of white insolvency practitioners. And the master, when introducing those policy guidelines, sought to address the previous imbalances that obtained as at that time. But now the problem is we had to balance Section 9.2, the remedial actions that had to be taken into account to try and balance it. And they would say there's a quota system. And as you would appreciate, and it would also say that you would have a white or a black practitioner and sort of getting the work from that white practitioners. And then we felt it cannot be right. So we sent the judgment to the Constitutional Court for confirmation, and the Concord agreed with part of what we said. And last time when I was here, the minister asked me what measures can be taken to improve it. And I said, if the master can have a boss barad or a workshop with all the insolvency practitioners, and they tell him how they want to run the profession, that would address, among other things, the question that you're raising relating to briefing patterns. So we don't have to be apologetic about the fact that they must be briefed.
Thank you, Justice Mathopo. Thank you, Acting Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, Acting CJ. Afternoon, Judge Mathopo.
Afternoon, Commissioner.
Let me commend you for being prompt and timeous in delivering, in dealing with urgent matters, especially the one that you touched the last time you were here. Remember the issue of COPE, Congress of the People versus Shilowa, heard on Friday afternoon. Then on a Sunday, the judgment was delivered. My question is, with your experience having acted in the Constitutional Court, what you have done with that case at the High Court, is it possible that you can take that spirit of dealing with an urgent matter and delivering judgment on an urgent matter as you have done with your experience after being part of Concord, and we have a better sense when you are dealing with an urgent matter?
Thank you, Commissioner Nyambi. I was part of the panel that dealt with an urgent matter at the Concord, which was heard on the 29th of December. And within 3 or 2 weeks, the judgment was out. So, yes, it can be done. And emphasis is it must be done. It should be done. If it's not done, then we would indirectly be failing the litigants and society. We should do it.
Thanks very much, Judge Mathopo. Thanks, Acting CJ.
No, thank you very much, Acting Chief Justice. Good afternoon, Judge Mathopo.
Good afternoon, Commissioner.
One of the issues that stand out from the BLA that they say about you is that you mentor young judges and especially women judges. What does this mentoring entails? Thank you very much.
Commissioner Mangwanishe, it means you go down to the level of a mentee and ascertain and what his or her limitations are, and try and assist and upskill, and also affirm. The most important thing is to affirm people that they can do it. Mentoring women judges is because there is a stereotype amongst the legal fraternity who believe that lawmaking or lawfare belongs to men, and that stereotype has to be put away. So that is what I had identified as something that has to be confronted head on, and to that extent, I have ran numerous courses, seminars, so that women can be equipped and be on the bench the same as I am, because I believe in one thing, that we cannot sit here and pretend and say women are inferior. They're not. They actually are. They help us and capacitate the bench much more, and they are much more heads-on and hands-on as far as determining other issues are concerned. So that's what I do. And over and above that, I've had the privilege of being, to use the word, exported to other countries to go and teach. I've been to West Africa and under the auspices of Sajay and with JP Mlambo having organized it. I've been to Lesotho, I've been to Botswana, teaching and explaining how South Africa operates. So this is what I do, and this is what I think I should continue to do.
Thank you very much, Judge Mathopo. Thank you very much, Acting Chief Justice.
Thank you, Commissioner. Judge President Mlambo.
Thank you, Acting Chief Justice. Good afternoon, Judge Mathopo.
Good afternoon, JP.
I'm going to be raising a question with you that's been raised with other candidates. And that relates to the delivery of judgments. I'm raising it with you because you are a member of the SCA. Can you compare the turnaround times in terms of delivery judgments of the SCA to the Constitutional Court?
Yes.
Please tell us.
We have an unwritten rule at the SCA that come end of term, to the extent practically possible, judgment must all be delivered. If there is one or two outstanding, it can be as many as 4 or 5. So colleagues know that judgment has to be delivered promptly. Now, you would want to ask me why at the CC you would have judgments being delayed for quite some time in ordinary period. It's a vexed question. The court tries, and colleagues try their best to ensure that judgments are delivered as promptly as possible. There's a lot going around in terms of when your first draft is circulated, colleagues would comment, colleagues would suggest a particular angle that you must follow. You would consider the comments of the colleague, and other colleagues would also give you their comments. It is in that exercise that you would see some of the judgments being delayed. And regrettably, I would say, yes, you would argue that we could do it differently, but the court tries. I would be remiss if I say they don't, the colleagues don't try. Sometimes, much to my what is the right word? To my displeasure, when the judgment takes a long time. I've been somewhere there as well, so it works hardship when the judgment is not delivered promptly. Remember, we've got norms and standards, so one has to look at the norms and standards and say, we're not different from other courts. We should try and toe the line and deliver judgment as promptly as possible. At the SCA, we try, and we do our best to do it. And the Concord, it's understandable why, in some instances, judgments are not delivered as speedily as possible. But I think more should be done to ensure that they are.
My second question, Acting Chief Justice, I've heard your response, and you seem to think I was leading us to the reasons why it's like that. I just wanted you to tell us the facts that can you compare the two courts? But here's my question now. You say you believe that more can be done, but isn't it correct that that's the apex court and that's the last court where people go to? More often than not, judgments there don't come out before 6 months. They actually take longer. Am I correct?
Yeah, that's correct.
And do you agree that the way that court considers judgments after hearing argument needs a serious revamp about how to go about ensuring that judgments come out timelessly?
Well, anything is possible. If anything is humanly possible, if you put your shoulder to the wheel. But some judgments, and there are reasons why some judgments delay, it's through no fault of the colleagues. You would write a judgment, and a colleague would make his or her comments. You would be engaging the colleague with that comments, and lo and behold, the time would fly. But yes, I agree that more needs to be done. When I was there acting, this is one of the issues that I lamented, and this is one of the issues that I addressed with a senior judge to say, where I come from the SCA, judgments are delivered as promptly as possible. Why are we having this delay in this judgment? And the senior colleague that I spoke to also said, yes, it's not acceptable. We should make sure that we deliver as speedily as possible. I agree. We should do more.
Thank you. One more question, CJ, if you don't mind.
Yes, yes.
This has got nothing to do with you, Justice Mathopo, but one of the judgments you have listed is the Premier Gauteng and others DA case. Were you the scribe in that matter, and has that judgment been handed down? It was heard on the 10th of September last year.
Yes, I'm the scribe in the matter. I'm told it was delivered this morning. It would have been delivered many, many months ago.
I see.
But it's attributed to the factors that I've raised. My judgment was out a couple of months ago. And if colleagues want to comment, colleagues want to make suggestions, you should engage and accommodate.
Thank you, Acting Chief Justice.
Thank you, Judge President Mlambo. Deputy President Betze.
Thank you, Acting Chief Justice. Good afternoon, Justice Mathopo.
Good afternoon, DP.
Earlier, you made a reference to the doctrine of common purpose insofar as it relates to crimes of rape. And you mentioned the case that you wrote. My question to you is, what would your response be to someone who says that far from you developing the law, you in fact turn it on its head?
That person would not be living in South Africa. That person would certainly not have seen or experienced what our women are experiencing. And that person's comment would be an affront to the women in our country.
Thank you. My second question to you, you mentioned earlier that you have been at the SCA for 7 years, and currently the complement of judges there is 25, headed by the president of that court, Justice Meyer, as number one. How high up the hierarchy in that number, between 1 and 25, are you currently?
I'm now part of the Big Five.
I think he doesn't like top six, he prefers big five.
And how do you find it now that this is where you are at the moment? Has that in any way had a bearing on the responsibilities that you have had to assume?
Oh yes, and now I have occasion to preside in matters, and that has thrust upon me a huge or tremendous responsibility to ensure, i.e., that judgments are delivered on time. I run the court with the proper decorum befitting a court, and that the counsel who appear in the court are given the utmost respect and the time that they need to present their cases. Not necessarily that they were not given time.
And lastly, through you, Acting Chief Justice, and I take it that that has somehow changed your perspective in relation to the top six, or so-called.
I think the issue about the top six was taken out of context and misunderstood. I said in my previous interview that it is not through any fault of the colleagues who happen to be at the top that they found them there. It's through years of experience that you end up being there. That is why now I am in the Big Five. And the others have left through a process of natural attrition. So that's what happens.
Thank you, Justice Mathopo, and thank you, Acting Chief Justice.
Thank you, Deputy President Petse. Before I go to Commissioner Madonsela, after whom I'll go to Commissioner Malema, let me check commissioners who are virtual, if anybody has any question.
Singh, Acting Chief Justice.
Yes, Commissioner
Writing
Singh.
back, please, Acting Chief Justice.
Okay, thank you. Commissioner Singh?
Thank you very much, Acting Chief Justice. I'm glad that at last, after serving many years on this commission, that we have a different understanding of the top six as we had right in the beginning, because the top six in the beginning didn't have a similar function as the top five that we have now. Thank you very much, Justice Mathopo. Thank you. I'd just like to compliment you on your commitment to ensuring that we have a judiciary that is more representative on racial and gender lines. Now, I'm going to give to you a hypothetical scenario. You are conducting an interview, and you have a male and a female who've done both, who are both suitable for appointment. They've done well in their interviews. Who would you be considering or recommending for appointment in a hypothetical scenario? That's question one.
Commissioner Singh, one has to look at the historical imbalances. And we have to ask ourselves and look at the composition of the bench. Where are we and where do we stand in terms of gender sensitivities and otherwise? If you have two candidates, both male and female, and then you look at the numbers and you realize we have not advanced the numbers, you would have the courage to say it is about time that the male candidate must stand down and the female candidate be promoted. Nothing wrong with that.
No, thank you very much. My second and last question, Acting Chief Justice, will be, Justice Mathopo, we who sit on the outside and we are not lawyers and, like you are and others, sometimes get a bit confused, miffed, perhaps that's not the right word, about minority judgments, although it is a right at the CC level. What is your view on minority judgments and the message it sends to the public? Thank you.
Well, minority judgments, since time immemorial in the legal profession, have been there, and they should be there. Remember, I said a minority judgment today can be law tomorrow. And it is important that those minority judgments be written, and colleagues must express themselves as to how they differ or they concur with the other judgments. Society would be enriched to know that the Constitutional Court, not because they sit and bank, they just decide like sheep to the slaughter and say, no, we follow this and this is the conclusion. No, we should write minority judgments, and there will still be minority judgment. Not in the Court, in all the courts. In the SCA, we do have minority judgments. I would encourage it.
Thank you, Commissioner.
Thank you, Chief
Singh.
Justice.
Thank you. Was it Commissioner Breitenbach who also indicated she had a question?
Yes, thank you, Acting Chief Justice.
Yes.
Good afternoon, Judge.
Good afternoon,
Mathopo.
Commissioner.
How are you?
I'm good, and you?
Fine, thank you. What, in your view, is the single most important attribute of a constitutional court justice, and why do you hold that view?
There's one only. You've got to be independent, fiercely independent.
Thank you, sir.
Thank you, Commissioner Breitenberg. Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Justice Mathopo.
Afternoon, Commissioner.
What is the value, if any, of a judge acting in the Constitutional Court before making himself available or accepting nomination in that court?
I'll give your answer in two ways. The first is, having acted at that court, I had a fair understanding of the workings of that court. And coming from the SCA, where things are done slightly different from the Constitutional Court, I then realized that there was value in me being afforded the opportunity to act in that court and understanding how applications and judgments get written and delivered. Then there's this same side of the coin. We have Justice Matlanga there, who never acted at that court, as far as I can recall, unless I'm wrong.
Actually, he did.
He did? No. All right. No, then I withdraw.
In his previous life.
No. Okay, in his previous, then I withdraw.
Well, I may be wrong, but I think Justice van der Westhuizen, who has retired, was appointed without having acted.
Yeah,
in
straight
that
from the
court.
High Court.
Yeah, if I'm not mistaken. Okay, all right. Outlet. Okay. I was hoping for one question only.
Okay,
No.
I can forfeit my. It's not.
No, I'm not putting pressure. Okay.
No, I'll leave the other commissioners.
Okay, no, that's fine.
In the interest of time.
Okay. Commissioner Malema?
No, thanks. I think you have dealt with this question, Judge, but I just want to satisfy myself. This thing of norms and standards, they only apply in High Court and to a particular extent SCA, or they also apply at the Constitutional Court, because my layman's understanding of those norms and standards is that in 3 months' time after hearing the matter, you should give judgment. And if it goes beyond 6 months, then the head of court must start now being alarmed. And there's a point where you even have to now start reporting to the JSC if there is no movement. But let's take a matter like the rescinding judgment of the Constitutional Court, where the judges are told, lawyers, within weekend, you must do the impossible. And then the matter must be heard. It's got to be heard. And then the Constitutional Court just take time. An impression has been created in the country that, this matter, the way is so urgent. People are even called on Saturdays to do this and that. And then the Constitutional Court just goes quiet on us. The country is burning. There is uncertainty in the country. How do we deal with that? Where is these norms and standards? Because leadership yourselves at the Constitutional Court, you must lead by example. It can't be that certain people at the lower level must behave differently and you ask people to do that which you can't do. So I just need some clarity there so that I can be comfortable knowing that all of you, these norms and standards are not just created for some high courts only, and then constitutional courts have got their own norms and standards, because all of you who come here say to us, it's very difficult, the colleagues must do this and they must do that, as if it is justifiable for constitutional court not to be within the norms and standards. And if the norms and standards don't apply to the constitutional courts because of those dynamics that you are trying to take us through, let us be told that no, these norms and standards can't apply because dynamics are different. So we know we don't hold you according to the norms and standards.
Commissioner Malema, it's a fair and valid concern that you're raising. It would be remiss of the judiciary to have norms and standards which are applicable to other courts and not applicable to the Constitutional Court. I think the ACJ is here, and he's aware and of the concerns raised by not only you, by other members of the commission. I think when he goes back, he will take it to the justices to say, this comment or this concern has been raised. Let's try and be as expeditious as possible. It's a fair comment.
Thank you. The last one, acting CJ.
Yes.
This principle you applied on male and female, where they both perform well and in line with the empowerment and the historical background of where we come from. Does the same principle apply on white and black male? Because, you know, there is an impression created here that if you perform well and a white colleague as well performs well, and we appoint a black male on the basis that we want to address the historical imbalances, we are wrong to do that. So, if there is a black male, a black male and a white male, they are both suitable and they've performed well in this interview. Will we be wrong to go now beyond the issue of performance to look at the historical background and how we seek to transform the judiciary and ensure that the previously disadvantaged, they too participate at that level?
I think, Commissioner Malema, the commission mandates you to do that, to go a step further, and unapologetically so.
Thank you, Acting CJ.
Thank you, Commissioner Malema. Commissioner Pofu.
Thank you, DCJ. DCJ, my hand was up before Commissioner Malema, but I don't know which standards you are applying.
Well, Commissioner Pofu, let me make a confession, but it's not a confession. Somehow I see your name was crashed here when it was under 6 and Commissioner Malema was under 7, but yours was crashed. I don't know how it happened.
No, I think no, I'm complimenting you. But just to say, those other standards don't apply here. Thank you, Commissioner, Judge Mathopo. Yes, I'll also ask you one question. I ask one question because my questions come with preamble. What Chief Justice Mogoeng called preambles. Now, mine goes to the question of transformation, which, thanks to the fees must fall generation, is now fashionably called decolonization, I think, and more properly so. You have spoken about debunking the myth that, for example, only men can be good lawyers or good judges, which is a belief that was held, and I'm sure some people even still hold it. But my view is that, you know, if we don't transform, we'll never know, because we don't get into the unknown. And I want to ask that question in relation to the time when you started acting. It was believed that judges, good judges, can only come from the ranks of advocates, and even not just advocates, senior counsel at that. And as I say here, because we can demonstrate it here, that myth was completely misplaced. Sitting here on my right, these luminaries, legal luminaries, would not be sitting here if that myth had not been debunked, because all of them, including the minister even, came from the ranks of attorneys. Now, the real question is this: do you think that in the spirit of decolonization, we should still have this divided bar of advocates, attorneys, and more particularly in relation to access to justice for the poor and black people? The idea that you must now have two lawyers, you must have your attorney, and then you must have an advocate. If you want, you want. That's a different matter. I'm talking about it being compulsory. What does it do to access to justice, and what can be done to debunk that particular remaining myth, or what we inherited from the colonial legal system?
The reality of the situation, Commissioner Mpofu, is with the advent of the Legal Practice Act, the resistance that the profession has is from members of the bar, the likes of, should I say, you and Madonsela and the others, who do not want to embrace the fact that attorneys are as equally capable as advocates. And I've said this before, and I'm going to say it now. It really doesn't make sense to me, because advocates get their work from attorneys, but then they want to push this unequal treatment. And what it does correctly, it impacts on access to justice, because the poor client has to pay 2 lawyers to get his case or a case to a court. That is not right. I think the profession must take a journey into itself, interrogate the issues, and say, let's debunk the myth, let's discard and do away with this dichotomy, which is not helping at all.
Thank you, Chair.
Thank you, Commissioner Mpofu. Then Commissioner JSC.
Thank you, SJ. Commissioner Malema has stolen all my questions.
I'm so happy
I have nothing left.
Hey, I'm so happy you stole all your questions. Well, Commissioner Malema, do it again. Commissioner Schlemmer.
Thank you, ACJ. Good afternoon, sir.
Hey, good afternoon, Prof.
Are you well?
Yes, as well as you can see.
I would just like to know from you, when the JP Lombo asked you questions, you said there were 25, or I think it was the Deputy President, there were 25, or there are 25 judges at the SCA, and we only have eventually 11 at the Constitutional Court. As part of the Constitutional Court being the apex court nowadays, don't you think there should be an increase in the number of people at the Constitutional Court? Or is there something else that we need to do to assist with, I think, the workload as well as the delays that is coming, that we experience?
I hold drastic and aggressive views to that question. I'm not sure if I can share it with you, but because you've asked me the question, I think it talks to access to justice. You may say, do we need 2 appellate courts, SCA as well as the Concord? I hold a view that I think the time has come. We should seriously look into the question of whether the 2 courts cannot be fused, and so that the people can access justice quite quickly and speedily. And let me perhaps share with you how I look at resolving the issue. You have judges retiring at both courts, right? If you hold that view, you don't replace them. You would have a model where you would say you want the Constitutional Court to comprise X number of judges. And if, say, for example, you say 15 judges for argument's sake, as and when judges retire at both courts, or say 20, you don't replace them. Then you would have a Constitutional Court that would run dealing with all cases that were exclusively belonging to the domain of the SCA and also at the Concord. And then you would look at whether you would have that panel comprising 11 or you reduce the number of panel. That's a huge, like I said, it's a drastic measure that would require the intervention of the minister and all the role players to decide whether you need that or not. So in short, that is my answer.
Thank you. I appreciate that.
Thank you, Commissioner Schlemmer. I think we have, there is one more question, Commissioner.
Thank you, ACJ. Good afternoon, Justice Mathopo.
Good afternoon, Commissioner.
Justice Mathopo, thank you so much for your commitment in training women acting judges and the practitioners. And I can attest that also Saula invited you not so long to train its members on trial advocacy, and the interest there was very high. That shows that women legal practitioners take training very, very serious. But the challenge that we are having, Justice, I hope you also know that one, is the exposure of women legal practitioners in other field of the law. I know there are people who are watching these proceedings who might assist in this one. What advice can you give on what should be done to make sure that women legal practitioners are exposed enough in these other legal fields so that we can achieve the transformation that we all want? Thank you.
This question talks to briefing patterns. We have been agitated for quite some time that briefing patterns should change and previously disadvantaged practitioners should be given briefs. In the commercial world, we don't get those instructions. Banks, corporate South Africa has not fully embraced the competency of black practitioners. It's a sad indictment. That said, you have the state attorney's offices, right? And the Department of Justice is the largest or the biggest consumer of legal services. I remember when I was in Johannesburg, I took it upon with the state attorney to say, have a roster or a system wherein you could brief women lawyers and not brief them in terms of the numbers, brief them in terms of the quality of the work so that they can improve, they can be upskilled. I was given the assurance that it was done. And when I see the advocates appearing before us in courts, it's not happening.
Thank you, Justice. Thank you, SJ.
Thank you, Commissioner Makula.
Thank you very much.
Oh, I'm sorry. Yes.
I just have a follow-up on the last
okay, all right.
response.
Okay, because it referred to the department.
Yeah.
Okay.
But also because his answer also refers to the judgment that he delivered on the insolvency practitioners, where he declared in particular what is almost like a court assisting. And in his answer, he wants us to do exactly that he declared to be unconstitutional. So that's why I want this follow-up that
Well, Judge Mathopo, the minister is saying, in other words, if you thought because it's this time they are sleeping, they are not sleeping. They are listening very carefully.
It is noted.
I wanted to say the Minister Masenwara will do a rescission.
Okay, all right. Commissioner Mapisa Ngagula.
Thank you very much, DCJ. Good afternoon, Judge Muto.
Good afternoon, Commissioner.
I thought that was very magnanimous of you to suggest that, yes, if you have a woman candidate and a male candidate, and even if they perform at the same level, that you would give to the woman candidate, so that we can address the imbalances.
You might wish to speak up.
So that we address the imbalances of the past. I really thought that was, if I don't say it, I won't feel good about it. But there's this, I'm following up now on a matter which you just raised before you answered the last question, which is fusing the two courts, the SCA and the Constitutional Court. Now, I'm talking from a lay person's point of view. I'm sitting here, and for some of us who served in some of these areas, other than what you are doing, when a case goes to a constitutional court, I can assure you, I'm telling you now, once you hear your case has gone to a constitutional court, somebody has taken you there, you immediately, your reaction is that, oh my Lord, whatever decision they take, it is final, I cannot challenge it, it is the end of the road. Okay? Now, I may as well be speaking on behalf of those who are serving in the other arms of the state, which is your legislature and the executive, but maybe ordinary citizens as well. So my question then, if you're saying there must come a time where you fuse the two, what happens? What happens to the ordinary people who believe that, okay, in Judge Mlambo's court at the High Court in North Gauteng, I may have lost this one, then what does it mean? It then goes directly to the Constitutional Court if we are to fuse the two. And of course, when it comes out a ruling, there's nothing you can do, because we all say that's the apex court, there's nothing you can do, you have to abide by the decision of the court. I know you've given this a thought. It's something which has, I'm sure, preoccupied you over a long period of time, but I can assure you that in the same way, other people who are elsewhere, who may be affected by that, would be concerned. I'm just throwing it. Thank you. And I did say that this is from a lay person's point of view, so I need help.
Perhaps let me try and allay your concerns. And to do so would be to give you the hierarchy and the structure how court cases progresses until they get to the Concord. You would have a case litigated at the High Court. If it's a single judge, that decision would be taken to a full bench comprising 3 judges. And then if there's a further appeal, it goes to the SCA, 5 judges. And the last appeal goes to the Concord, 11 judges. So the problem that a litigant may face is, may not have the money to be litigating all the way from the Constitutional Court until from all the way to the Constitutional Court. And that may impact on that litigant's access to justice, because we say, I don't have the money to go with my case, and then becomes a problem. But if the litigant knows that the route to the top has been short-circuited by legislation, and the litigant would have comfort and confidence that my case will be heard as speedily as possible. But if it has to go via Bloemfontein and come back to Braamfontein and I'm in Joburg, that's another problem.
Actually, Joburg is too close to Braamfontein. Imagine Polokwane. to Braamfontein.
I think we are done with this interview. Thank you very much, Judge Mathopo, for availing yourself. We appreciate it. I will now excuse you